you for joining us at the bar for another spirited conversation about issues at the intersection of law, politics, and culture. I'm Jennifer Braceras from Independent Women's Law Center, and I'm joined by my colleague Inez Stepman with Independent Women's Forum.
And today we're going to be talking with Robby Soave, senior editor at Reason, host of Rising on Hill TV. Robby's the author of 2 books, Tech Panic, Why We Shouldn't Fear Facebook in the Future, and Panic Attack, Young Radicals in the Age of Trump. But what we wanted to talk to him about today is his excellent reporting, setting the record straight in 2 infamous cases of media malpractice, right? We have the 2014 Rolling Stone hoax article about sexual assault on the University of Virginia campus, and then the 2019 incident involving Catholic high school students at the Lincoln Memorial. But more generally, he writes a lot about issues of due process and civil liberties. So we thought he was the perfect person to talk with us at the bar today. So Robby, welcome.
Thank you so much for having me. Good to see you.
Yeah, so we were just discussing this off air, but the Title IX regs that recently closed their comment period, they contained so many sweeping changes to American law, and we've spent a lot of time, I feel like, on this show and elsewhere talking about the fact that they are redefining sex and potentially flipping around the language to essentially make this statute from 1972 say the exact opposite with regard to sex discrimination and protecting women and girls as it was intended. But because of all of that furor, there hasn't been as much focus on what I think, absent all of that, that radical change would be the center of the conversation around Title IX, and that is due process issues on campus. So, I just hope that you can come in on and talk to us about what you think these changes are going to bring us back to. You did a lot of reporting on the early part of this sort of due process on campus. The Trump administration came in, established some very minimal due process safeguards. Then we had a pandemic, and all the colleges and universities were essentially unpeopled in key part for this issue. There weren't a lot of late night parties on campuses that tend to spin off these kinds of sexual assault issues. And now people are back on campus, and we have this new set of Title IX regulations. So what are the changes that are made from the previous changes, and what do you worry about with this new set of Title IX regs?
Yeah, frankly, I think they're horrifying. They're very dangerous, and I try not to be prone to hyperbole in general in like political commentary. It is quite bad. It's extremely bad. It's going back to a lot of what we saw prior to the Trump administration under President Obama, which was the kind of genesis of these new threats to due process on campus when the Obama administration released guidance in, I think it was 2011, on how colleges and universities should adjudicate sexual misconduct and sexual assault accusations, moving them. It moved them, again, and actually not under actual rulemaking, just under guidance. They essentially wrote letters to colleges and universities and said, we think you should do it like this. Feel free to disagree and go your own way if you want. Maybe your federal funding is in jeopardy if you do that. Who knows? Let's find out if you really want to. Of course, no institution actually wanted to do that. So they really fell in line with what were some quite bad policies. And then the Trump administration came in, went through the formal rulemaking process to codify a set of principles more in accordance with just basic kind of presumptions of innocence, like just very basic standards of how justice is supposed to operate in the Western world, in a post-Enlightenment society. Now we are going back, unfortunately. President Biden and the Education Secretary have vowed to go back and have proposed doing just that. So there's a lot of very significant changes, but to get into the details, they are allowing, once again, a single investigator model. So if you're accused of sexual misconduct, which could be everything from like actual forcible sexual assault to harassment to speech, to just speech that wouldn't be criminal in any other context, it can now be, once again, and this was the way it was under Obama guidance, and now it'll be like this again, it can be adjudicated by essentially a single administrator who would receive the complaint, who would choose who to interview about the complaint, which witnesses, which evidence to consider, and then they will compile a report. And then typically another administrator or panel of administrators will decide what to do with that report. That whole process could take place without the accused having any meaningful way to confront whatever witnesses or whatever evidence is against them. I mean, this was a key component of the DeVos Trump reforms, was that just like in a criminal proceeding, you should have, maybe it's not the exact same extent, but you have some right to confront whoever is making accusations against you, or to pose questions to them. So under the Trump guidance, it was clear it doesn't have to be you yourself confronting the other person. That is not called for, but your representative, your attorney, has to be able to question them. And now that process, I mean, the requirement for a hearing at all is gone under the new proposals, and that would be that could be very, very, very bad, because if you kind of believe in the principles of due process, adversarial hearings are one of the best tools we have to arrive at the truth.
Right. And so they're not just principles, they're constitutional requirements when you're talking about public universities. And one of the most basic constitutional requirements is notice and an opportunity to be heard. And from my research, one of the biggest problems with the way colleges were handling these types of disputes between students prior to the rules that were issued by Betsy DeVos and the Trump administration was that they were essentially putting out notices that said things like, you have been accused of sexual assault sometime last fall. And, the student would sort of ask or have their lawyer call up the general counsel and say, well, can you be a little more specific? And I had one lawyer tell me just the other day that when he did that for one client, the response of the Title IX investigator was, he knows what he did. Right. And so then, not the student doesn't have an opportunity to rebut because he doesn't know, what exactly he's being accused of doing. Where did the wrongdoing take place? Many of these cases involved students who had been in a consensual relationship with each other, sometimes for many months prior to a breakup. And so the student wants to know, well, on which of the occasions that we had sex is she accusing me of assaulting her, right? But the information wasn't forthcoming. And that's the type of thing that the DeVos regulations really tried to put a stop to, and said, no, you need specific, you need to give specific written notice. You need to take a written statement and provide written notice, and then access to the file to the student. Now it's gone back the other way. Tell us a little bit about what the new rules say with respect to notice and being able to view the evidence.
Yeah, this is a huge change, and again, very, very bad. There will no longer be a requirement that the accused students get access to, a summary, the literal charges against them, and then the evidence against them. So previously, I have the exact wording here. Under the DeVos rules, both sides, accused and accusers, were entitled to inspect and review any evidence obtained as part of the investigation. Under the new rules, so that is very key language. Under the new rules, the parties are only guaranteed a description of the relevant evidence. And this description need not be written down. Administrators can provide it orally or in writing. So orally could just be the investigator, again, this sole bureaucrat in charge of the entire proceeding, could just tell you, here's what the accusation is, and they could get it wrong. They could misspeak. This has happened. I've covered Title IX cases where the accused has said, what they told me I was accused of, they were not clear about it. It was not what I actually, then when I showed up for the hearing or the later stage of the proceeding, it was something completely different. Wow. And it's your word against theirs because it's not written down. And that is just farcical. That just violates every basic proceeding, basic idea of how fairness works. And by the way, you're right. These are legal requirements. When these Title IX proceedings are adjudicated at actual courts, when students have lost or been the accused, is suspended or expelled, often forfeiting, being tarred as a sexual abuser, not being able to finish their education, possibly being thousands, maybe hundreds of thousands of dollars in debt. I've heard this happens to medical students who've been hundreds of thousands of dollars in debt, now have no way to finish their education. It is akin to, it's not the same exact thing as being put in prison, but it is so ruinous for your life, your your professional aspirations and your economic standing. But when they have, then sued the institutions for arguing that the proceedings under which they were suspended or expelled violate the actual Bill of Rights, the courts have agreed very often. The judges will actually go, wait a minute, there was no hearing, you didn't know what the evidence was, you had no way to confront your accusers. They've laughed at that idea. They have clearly established, in the circuit courts have repeatedly said, no, there really needs to be some kind of confrontational ability in a hearing. So to have the Biden administration say, no, we're just not going to do that, no, is really flying in the face of what actual judges have said about these proceedings.
Could you walk us, because you just kind of alluded to one of the examples that you wrote about, could you walk us through some of the more egregious due process violations that you've found in your reporting? I mean, things like Jennifer was referencing where, the Title IX coordinator says, what you did. I mean, like, what are some of the more egregious due process violations that you've come across while reporting on this stuff?
I mean, they're so incredible. And we haven't had as much of them really in the last few years just because of the pandemic. And that's another thing, that we haven't actually had time to test the new rules at all. Like, if they were really bad and just like allowed for some huge number, a disproportionate number of new sexual misconduct episodes, I guess maybe that would make some argument for revising them again, but that we've had no time for that to happen. But yeah, under the kind of Obama era, or before they were reformed, I covered cases so interestingly enough, the theory of this being it is a violation of Title IX, and the university is obligated to do something, even if the supposed victim disagrees. So I have covered cases where the supposed victim, the person who was supposedly a victim of sexual misconduct, it was a third party who reported it, who said, it could be, oh, these two people are dating and I'm jealous, or I don't like this person, or I don't think they should be dating. And a third party reports. And then the university must, because it was the hair trigger for these investigations, had to investigate it. And they had interviewed, in some cases, again, the person who's supposedly the victim, and the victim said, what? we're still in a relationship. We're still in a relationship where there's nothing wrong. And the university has followed through, and like, that should be the end of it, right? If the supposed victim says, no, there is no, I don't wish to pursue, I'm not claiming anything, it should end. But it had to go forward. There was this was a football player at, I believe, a school in California. It might have been one of the UC schools. I can't remember exactly which one it was. Matt Bormeister was his name, who went through this proceeding and was subjected to an extreme sanction for this, again, against the wishes of his girlfriend. So the involvement of third parties has been a huge issue. The medical student I alluded to, it was a Michigan State student whose case I covered, who ended up with hundreds of thousands of dollars in debt after he was expelled. Following a night where he had two bad hookups. Everyone got really, really drunk at a party.
Wow, busy guy.
Yeah, right. It happens. And a lot, when you look carefully at these cases, you find virtually all of them involve intoxication with alcohol and drugs on both sides. And then you have people, the men and the women involved, making choices that they probably would not have made if they were sober, etc. Like wrongdoing, moral wrongdoing, whatever kind of blame you want to assign, fine. But it's not the same as saying it's sexual misconduct. Like, who is consenting here? It gets into these very blurry, like, well, what if the other person is also intoxicated and actually was the one who initiated the encounter? But if they're the first to report, there's such an advantage to reporting first. And that emerged in so many of the cases I covered. Like, honestly, the advice would be, if you wake up and you don't remember what happened, like, you should be the first to the Title IX office, just in case the other person files an investigation. I know that sounds perverse,
yeah.
but because if you're the second person, then your claim is retaliation, which is not allowed under their interpretation of Title IX. And that's without getting even into all of the cases that are mere speech, where people were investigated for saying something of a sexual nature in a classroom, or writing something of a sexual nature. It could have been perfectly germane to a conversation of, like, sexual assault in Shakespeare's works or something like that. And if it offends someone, obviously this has happened to professors like, Laura Kipnis, people, probably names that are familiar to your audience, but it was so bad on so many fronts, and I'm really worried we could go right back there.
Yeah, could you follow up a little more on we haven't really gotten to the harassment, broadening of the definition of harassment. So what does this batch of proposed Title IX regulations, how does that deal with, because again, there's this story where prior to the Trump administration actually codifying and actually putting out, APA regulations on this, we had universities that had expanded the definition of sexual harassment to include things that no sane person would ever call sexual harassment, like general statements about sex roles or controversial presentations, right? We even had students filing Title IX cases against Brett Kavanaugh, right? Like for essentially
Yes.
for being in the public eye in the maelstrom of his confirmation. So where do these new regs go on the harassment thing?
Right. So the previous guidance, the guidance by the Obama administration, I believe their exact phrasing was any unwanted conduct of a sexual nature that is severe or pervasive, and there was no qualification that it be objectively offensive or anything like that. So that could include and did include anything. And you know what? Even if it doesn't, people could file complaints, right? They could say, well, this is uncomfortable or offensive to me, and then you go through this administrative process where people don't even know what the evidence is against them, and it's terrifying to the people accused of something. Even on paper, you were accused of sexual misconduct. What people assume that means, even if what it actually was, right. Even if what it actually was, you used the wrong pronoun for someone, or you used a gendered salutation when that was contrary to their desires. So then the guidance under the rule under DeVos was going to be severe and pervasive and objectively offensive, except in the case of, and I agree with maintaining this, except in the case of quid pro quo harassment, where so even under DeVos is saying, a professor says, you have to sleep with me or you have to give me a massage or something for a better grade. No, that is harassment. Like, it doesn't have to be offensive to that is just harassment. That's in keeping with kind of a corporate definition of what harassment is. But for just comments, you need it to be like well outside the bounds, given that we're in a university setting where people really are supposed to ideally be free to express controversial and contrary ideas, to arrive at some broader truth. We're arguing right now as a society about concepts relating to gender and sex, and it's important to be, especially in relevant in sociology classrooms, in gender studies classrooms, in literature classrooms, and we were closing the door to a lot of legitimate conversation. That's something professors were finding. Professors were telling me when I do reporting on this, they're saying, I'm afraid of my students. I'm afraid I just can't address this subject. Law professors were saying they did not want to teach the law as it relates to sexual assault. Can you imagine what a setback for feminism? It's been a massive win for women, for victims of domestic violence, or just women who are victims of violence in general, that we have attorneys and judges and juries and prosecutors who understand the plight of women in that situation and take their claims seriously and listen to them, not automatic belief, subjecting them obviously to due process, but hearing them and being knowledgeable about the statistics and what these things are like. Now law professors are saying, we can't teach this anymore, because what if someone in the classroom is offended or bothered or triggered by it? They could file a Title IX complaint. That was under that's how it was previously. And, we could be going right back there.
Well, I think part of the problem is that generally in society, people define sexual harassment more broadly than the law defines it. So a lot of people don't realize, for example, that sexual harassment in and of itself doesn't violate federal law. It violates federal law when it amounts to sex discrimination, right? So it's not the dirty joke that violates federal law. It's when conditions of employment or conditions in a classroom become so unequal and so unfair to one sex or the other that it rises to the level of discrimination, that's when it violates the law. So, a school, for example, that punishes, punishes girls who make crude remarks, but not boys, is committing discrimination, right? And the school itself has to commit the discrimination. A school that tolerates sort of verbal, specific and targeted abuse of a person on the basis of their sex or of women generally, right? In a particular course or across the campus, that institution is engaging in unlawful discrimination. It's not, the school isn't violating the law if at a frat party on a Saturday night, one boy makes a comment about a girl's physical appearance that somebody else finds offensive. The school doesn't even know about that, right? They don't know about it until it's reported. And even if it is reported, that's not, the school doesn't have to necessarily do anything as long as they're treating everybody equally, right? I mean, they're not supposed to be policing speech.
Yeah, I mean, well,
just to jump in before. I mean, that's exactly what the Davis against Monroe case is dealing with, right? You're talking about the school repeatedly ignoring the like harassment of a particular female student and allowing a boy to basically follow her around, harassing her, sexually harassing her repeatedly. And there you really are dealing at some level, whatever one thinks about that case, like really dealing with at some level the school ignoring persistent sexual harassment to a point where maybe it is difficult for her to get her education.
Yeah, it's well, it speaks to the difficulty, I think, in even actually adjudicating some of these things under the framework of discrimination to women. I mean, look, I've covered cases where it was two men, right? And that's still being adjudicated by Title IX. But it's like, where is the sex-based discrimination in this? We're kind of like, now we're just kind of like lumping everything together.
Yeah, no, it doesn't exist today. Unless the school is treating instances of complaints by men differently than complaints by women, right? It doesn't necessarily matter who the two people are in the relationship. What really matters is the sex of the complainant and how the school responds to it, right? That's when Title IX is invoked. And of course, there are state laws that just prohibit sexual harassment outright. But when we're talking about federal civil rights law, we're really talking about discrimination, not, harassing language or speech. It can't be. It would violate the Constitution. And yet, and the courts have been very clear about this, but despite the courts being clear about that, the culture at large and the universities in particular have just gone full force with this broad definition of what they say they have to prohibit and crack down on because of federal law. And it's just not true.
And it's simply impossible to ignore the fact that this approach, you want to talk about discrimination. From my reporting and from excellent reporting done by Emily Yaffe, it emerges, and there's just no way around it, that far and away, disproportionately, men of color, Black men, immigrants of color are, like, it's apparently obvious, are far more likely to be accused and adjudicated and punished under the Title IX system, which, let's say if you're a progressive who is, or I mean, some conservatives and libertarians concerned about this too, right? About unequal treatment in the criminal justice system. I mean, well, here you go. It's happening. It's happening in this, quasi-judicial proceeding that actually doesn't even come close to what the criminal justice standards are for protections for the accused. And you have all these cases where, like, race is very much in the conversation if we're talking about discrimination and the sort of gender-based discrimination part of this. In your kind of privilege hierarchies or whatever, in this narrow context, at least. I don't know if this is generally the case for how, various kind of claims of privilege or oppression are adjudicated, but the gender was going above race for sure in a very interesting way. It was interesting to see who ended up caring about that. Not enough progressives, in my view.
No.
Yeah. What do you think we're likely to see now that we're returning under these new Title IX rules? I mean, where are these cases going to go in the actual courts, right? Because as you mentioned before, for the small percentage of people who have the resources and the like sort of willingness to continue to pursue this, a lot of them have found victory and settlement in actual federal courts that have actual due process standards. I mean, what do you expect is going to happen between the clash? Because some of these regulations don't just contradict the sort of plain reading of the statute; they contradict Supreme Court decisions.
Yeah, frankly, they force the universities and colleges to in between a rock and a hard place. Like they will run afoul of the federal government if they don't do this, but they know if they do, they eventually end up in court when they do it. And it's a grueling procedure. There's no guarantee of a success for people who are suspended or expelled or what have you. They don't, there's no way to make people entirely whole after being wrongly expelled for sexual misconduct. There's no financial way to make you whole. There's no professional way. But if you look at the numbers, Casey Johnson, who's also an expert on this subject, who's a professor at Brooklyn College, and closely follows these cases, he's compiled them. I believe that the most recent statistics I saw from him, and they're from a while ago now, but it's something like somewhere in the neighborhood of half the lawsuits brought by students falsely or who say they've been wrongly accused because of a due process or wrongly punished because of a due process violation. So they're winning somewhere in the ballpark of half the time. Maybe not winning completely, but winning in some sense, which is a pretty stunning failure rate, a pretty stunning rejection of this approach at the court level. I don't know if this is going to be eventually something the Supreme Court weighs in on. I guess that would be helpful. I mean, there's no real mystery for how a competent court will decide this. A competent court will say it is totally inappropriate, it is not acceptable to have a proceeding where there is no guarantee that the accused can see the evidence. There's no guarantee that the accused can consult an attorney, and there's no guarantee that the accused can put their questions to the accuser. It's just obvious that that's what a competent court is going to decide. So, my guess is we're gonna take a few steps back, and then maybe years from now we go back again when there's a robust of enough court presence to turn it. But in the meantime, we're going to see more of the kinds of cases we saw 10 years ago, and some lives are going to be ruined. And also, there are, to be clear, there are also cases where the accused is guilty, obviously, and this is an adversarial proceeding that sometimes the other person does not actually want to pursue. What I liked so much about the DeVos changes is that if both sides have some kind of dispute and they don't want an adversarial process, it's fine to have a restorative kind of, maybe you make right to the other person in some way without involving a formal punishment proceeding to go forward. And I'm not totally clear how much that if that is going to survive under the new regime. It might, but I think it's probably going to be more frowned upon than it was previously.
It's funny because they want restorative justice proceedings for everything else, like wildly inappropriate behavior in fifth grades, and restorative justice so popular, but on the left, but not in these cases that are genuinely. I mean, most of these cases are not at all what people, or at least used to think when they think about sexual misconduct or sexual assault. They're exactly what you described. They're gray area cases where both parties were intoxicated, dealing with sort of miscommunication at worst. Certainly not the kind of cases that I think people think about when they see that on somebody's record. They think you're a rapist.
Yeah. Well, and I think, what is the business of a university in adjudicating interpersonal relationships to begin with? I mean, clearly this is a big overcorrection because there were many cases in the past, in the 80s and before, where young women did go to their universities and tell them that they had been assaulted, and those cases were not taken seriously. I know many people that happened to. But I wonder whether the bright line rule for the school shouldn't be that when you're alleging sexual assault, this is a crime. The criminal justice system should play its part. And anytime a student is arrested for sexual assault, where the law enforcement authorities think that there's probable cause to believe that a crime was committed, in that case, the schools could have a bright line rule that person is suspended, until the completion of the criminal process. And if they're found not guilty, they can come back. But as long as you're being prosecuted by the criminal justice system, you're not a student on this campus, right? That to me, that would be fine. And it would be a bright line rule, and there would be some negative results to people who are ultimately found not guilty, but it would also, prevent, you wouldn't be kicking people out on an allegation where there's no process in determining anything. I mean, at least then there's probable cause enough for a criminal case to go forward.
An ancient allegation in some cases, to be clear, that's something I didn't bring up yet. But I think the average time between the incident and the filing of the complaint is like a year. These can involve long-running relationships, bad breakup. Year or 2 years later, the quote-unquote victim, files a complaint and says, on two nights that we were together, it was I had withdrawn consent or I had not given consent, right? The affirmative consent. I had not affirmatively said I consent. And then we were together the next night and the next night and the next night. Those were all consensual, and before it was consensual. But on these 2 nights 2 years ago, those were not consensual. A person could be expelled on that basis under the previous standards. Trying to recall the details of these cases, it's just kind of staggering. So I'm very, and what you just said is the impulse that so many people have. Even Bernie Sanders, I believe, said, years ago when he was first kind of asked about this issue, his gut impulse was to say, well, why are the universities handling this at all? Isn't this a matter for the police? Then he was set straight by kind of, victims' rights activists within the Democratic Progressive Coalition who, got him the right talking points on what you're actually supposed to say. But that was his impulse. That is most people's impulse. It is not a bad impulse.
That's the question I get, when I get calls from parents whose kids are caught up in this, and they say, well, if my child is being accused of assault, why aren't the police investigating? Or, the police aren't pursuing this. They don't think there's anything there. Why is the school still moving forward? And of course, the answer is, well, the school says they're not attempting to adjudicate whether a crime has been committed. They're simply adjudicating whether misconduct has been committed, right? That's so they think they have a right to move forward. But you're, as Inez said, essentially tarring somebody with the label of rapist, because that's what people think of. Yeah, it's a sad state of affairs. What would you recommend to parents or students who find themselves caught up in this? I mean, I know you're not a lawyer, you're not giving legal advice, but do they have to wait until they're kicked out and then, sue? Should they come to someone like you and have the egregiousness of their case exposed? I mean, what do you recommend?
Well, the first recommendation is, look, be very, very, very careful of hookup culture on college campuses. And I don't say that I'm not a social conservative. I'm not socially religious or anything. I'm saying for your own protection, develop healthy norms of drinking, be cognizant of other people's drinking. Someone who can seem sober to you, it can actually be very drunk. This is especially true of women who tend to be smaller than men, get drunk, intoxicated much more easily. On some of these campuses, the amount of alcohol. Again, I'm a drinker. I'm not for prohibition at all. In fact, I think some of the prohibition norms
for a reason.
Right,
Sometimes
right.
over cocktails, yeah.
And in fact, I think some of the prohibition norms have made some of this problem worse, because a lot of the drinking takes place in more binge drinking kind of scenarios, in basements, at frat parties, and it has to be illicit. It doesn't take place out in the open at bars because the kids are under 21, so they can't drink at bars. So there's a little bit less of, the responsible people, the bartender, the other people who know how to drink, hanging around and kind of looking out for people. I actually think that's kind of made it worse. But additionally, yeah, I mean, if this happens to you, you should absolutely consult with an attorney. You should, despite what the new rules say, you need to get clear records of exactly what you are accused of. You should absolutely talk to the media. You should shine a light on what they're going to do. Secrecy is these administrative proceedings' best friend, but there's just no guarantee. Like, actual innocence is no guarantee of having a favorable outcome. Like, it is scary. It is unlikely. Look, this does not happen to every single man on college campuses. This doesn't happen to everyone who has an uncomfortable hookup, but you should be very, 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 very careful.
I would also say, I have 3 daughters, 2 of whom are in college. I would also say, if you're a victim, if you are assaulted, go to the police immediately. Don't rely on the universities, because let's be honest, the universities don't have your best interest at heart, whether you're the victim or the accused. They really don't. They have one interest, and that's covering their ass and, having their statistics look right, that they did the right thing. So, I would say, if you, male or female, if you are assaulted on a college campus, go to the police, talk to your parents, talk to, another trusted adult. Don't leave it in the hands of a Title IX officer, because they're not out to help anyone except themselves.
Yeah. The advice I would add is there are groups out there that deal with this. There's FACE, which deals with exactly false accusations, and they are not only a resource for advice on how to deal with it, but also sort of support for what is a really, really difficult thing for especially particularly young men who are going through this. I mean, there have been suicides. It's a really tragic and awful thing to feel like your life is going to end in this way when you know that you didn't do anything. So there are groups out there for support, and also there are law firms that deal exclusively with this kind of litigation. They're very experienced in doing this. So definitely, I would add to all the good advice that has been given. Try not to put yourself in these kinds of situations. But if you are in that kind of situation, there are groups out there now. I think there's more awareness of this because of what happened 10 years ago. It kind of reached its peak on college campuses. There have been groups formed in response to it. There have been lawyers who are taking these kinds of cases and those interventions can matter earlier rather than later as well, right? Like, a strongly worded letter from a lawyer is sometimes enough to get the school to maybe back off something versus having to go through the federal court process afterwards. So yeah, I would second all that advice.
And it is not safe, even if we're not set aside, sexual assault, it is not safe for 18-year-old girls to drink, 5 shots of Fireball whiskey before they even set out for the night. That is not victim shaming or blaming. Even apart from sexual assault, like, that is not safe behavior. Drink responsibly. Have someone in your party, in your group, who is not drinking, who can look out for people. The perspective of one sober person can be just hugely beneficial. Use good judgment and train yourself to have good judgment. Because it's, I see surveys of like how much these kids are drinking, and it's just, it makes us professional adult drinkers look like, oh my God, I can't believe you're doing this. It's so dangerous. So please watch out for that. And I would say that, even apart from any consideration of rape or sexual assault, you just like drink responsibly and surround yourself with responsible people. Know the people you're with, know where you're going, know like what your plan is for the evening. This is just basic advice that can really save yourself a lot of woe.
Agreed.
Yeah, I think on that that excellent advice. We're going to wrap up here. So, Robby, thank you so much for coming on to discuss these new regulations in Title IX and the problems they've caused in the past. So thanks again for coming on At the Bar.
My pleasure. Thank you.
Thank you.
At the Bar is a production of Independent Women's Forum. It's available for viewing on Facebook, YouTube, and IWF.org. You can also listen to it as a podcast on iTunes, Spotify, iHeartRadio, or anywhere else you get your podcasts.
We hope you join us in a few weeks for another spirited conversation about issues at the intersection of law, politics, and culture. Until then, cheers.